Good time, okay. So we've called to order? Call to order. So can I ask, Senator Allen, can I ask you to say a prayer to start, please?
Dear Lord, as we gather together as a committee of this House of Parliament, we ask for your guidance, your intervention and direction in all that we do so that it may be to the benefit of our people and our country. Thank you for our many blessings that we continue to receive and open our hearts to continuous gratitude for such. These are the mercies we ask in your name, Jesus Christ. Amen.
Amen. Thank you, Senator Allen. Apologies for absence. I have apologies from Senator Charles Sinclair, Member Franklin Witter, Member Dr. Angela Brown Burke. Are there any other apologies for absence? Senator Allen?
Senator Crawford was expected to be late this morning, so I trust that he'll still be joining us.
Thank you. All right. Can we then invite in the team from the Sisters of Mercy? I'm sorry. Shall we deal with that before? Can I let me deal with that before? Let me deal with that before. Okay. Members, the question is the matter of the quorum of the committee. The committee comprises 14 members. Ordinarily, select committees have a quorum of 3, and special select committees and joint select committees, the quorum is determined by the committee itself. Our first meeting today, we are 4 in number. So can I get Madam Clerk, maybe you can guide us on what is a typical number for quorum? Well, shall we say 4 members? There are 4 of us here now. And the members in agreement with that? And that is inclusive of the chairman. Yes? Chairman. Inclusive of both, whoever is acting as chairman. Yes. Okay, so our quorum then is 4, including the chairman. Okay, so at this point, I think I will ask the team from the Sisters of Mercy. Thank you. All right, members, thank you. I want to welcome the team from the Sisters of Mercy, and in a moment I'm going to ask you to introduce yourselves. But I just want to welcome you to this sitting of the Special Select Committee to consider and report on private bills, and in particular today, the bill entitled, let me see if I can get the short act, an act to amend the Sisters of Mercy of Jamaica, British West Indies Incorporation and Vesting Law 1954. And I just want to make a few remarks in relation to the Sisters of Mercy. The Sisters of Mercy have been in Jamaica for many, many decades and have done extraordinary work in many communities in Jamaica, particularly made quite an impact in the education system of our country, and continue to support that kind of work. And so we are happy to see you. We are thankful for the work you have done for our country. Please convey that to your community on behalf of the committee. I then ask now that the team introduce themselves, and starting with Mr. Corey.
I'm Alexander Corey. I'm an attorney at law instructed by Livingston, Alexander, and Levy. With me today are Sister Susan Fraser, who is the area administrator of the Sisters of Mercy of Jamaica, as well as Ms. Marcia Taichon, who is the chief executive officer of the Sisters of Mercy of Jamaica. And on behalf of the group, we'd just like to express our gratitude to you, Madam Chair, and to the other members of the committee for taking out the time to hear us and to consider our bill.
Thank you. So, Mr. Corey, you want to just take us through the particulars of the bill and the work that it is you want us to look at today?
Certainly. Well, for those of you who don't know, the Sisters of Mercy of Jamaica, it has its genesis from the 1880s. That is when the Alpha Girls' School was founded on South Camp Road. And at the time, and up to 1954, when the Incorporation Act was promulgated, all of the property held by the organization known as the Sisters of Mercy of Jamaica was held on trust by individual sisters who were a member of the Sisters of Mercy, but also the wider Roman Catholic community in Jamaica. So what the 1954 law did was to create a corporation with separate legal personality known as the Sisters of Mercy of Jamaica, British West Indies, and it vested all of the property that was held on trust by those individual sisters in that corporation. Now, that corporation was formed on the basis of 5 sisters who are listed in Section 3 of the Incorporation Act, and those 5 sisters were tied to 5 specified positions. Now, what has happened over the years is that those 5 sisters who were originally named have all passed away, and further than that, the 5 positions no longer exist within the modern Sisters of Mercy organization. So we're in a situation now where essentially the corporation is not properly constituted because 1, there's no incumbents to those positions, and 2, the positions themselves are no longer recognized and no longer exist in the organization. Further, it wouldn't be as simple a matter as appointing new persons to those positions because they were originally based on convents. And for at least 3 of those convents that are named, there are no sisters that are members of those convents. So what the main aim of the bill is to do is to reconstitute the corporation by naming 5 new sisters with 5 new positions that are currently recognized in the corporation, with the flexibility to have the president of the Institute of the Sisters of Mercy in the United States to appoint 3 of those members so as to not encounter the difficulty that we have today, where they're tied to 5 specific positions with no flexibility for change. So, Madam Chair, that is the main rationale for bringing the bill today.
Do members have any questions at this point? Senator Allen?
Thank you, Chair. Mr. Curry, just to clarify, so I understand that you're seeking to reconstitute in order that the current structure would look more like today's structure. But did you say that you would be naming other sisters, or is it that it's a matter of the, should it be that we again name sisters because in another 20 or 30 years would we encounter a similar issue? and therefore probably have it more nondescript. I don't know if that might be the best word.
All right, thank you for that question. So, as it is stated in the amendment bill, there are only 2 sisters that are tied to positions. The other 3 positions would be filled by appointees of the president of the Institute of the Sisters of Mercy of the Americas. Be that as it may, all 5 of those positions in the modern Sisters of Mercy organization, which I should add is an international organization, our branch is headquartered in the United States, and it is intended for the president of that institute that we fall under as the Sisters of Mercy of Jamaica to appoint each of those 5 named positions. So 2 of them are tied to positions there, so I understand the reason behind the question, but it is intended for the president to appoint each of the 5 persons. And so really the only difficulty we would have in terms of continuity under that structure is if that institute or if the president ceased to exist.
Thank you, Mr. Curry. Any other questions at this juncture? Okay. All right, there being no other questions, can I perhaps then ask Mr. Curry if you could take us through the bill clause by clause so the committee members could have a better idea of what each provision is asking us to do.
Thank you, Madam Chair. Should I start at the recitals or only the operative?
Yes, go ahead. Start from the very beginning.
Okay, so to begin, this is a bill entitled An Act to Amend the Sisters of Mercy of Jamaica, British West Indies Incorporation and Vesting Law 1954, to make provision for the replacement of the offices which constitute the Sisters of Mercy of Jamaica, British West Indies, to make provision for the Sisters of Mercy of Jamaica, British West Indies to be conferred with express powers to govern its management and administration, and to validate and indemnify acts carried out by the Sisters of Mercy of Jamaica, British West Indies, in good faith during the period commencing on the 12th day of April 1954 and ending on the date of commencement of this act. Whereas on the 12th day of April 1954, a law was passed for the incorporation of the Sisters of Mercy of Jamaica, British West Indies, the corporation, and for the vesting of certain property in the body so incorporated. And whereas the several offices of the corporation listed in the said law, which were therein declared and appointed a corporation or body corporate, having continuance forever and perpetual succession by the name of Sisters of Mercy of Jamaica, British West Indies, being the offices of Local Superior of the Convent of Mercy, Alpha, Local Superior of Mount St. Joseph Academy, Mandeville, Procurator of the Convent of Mercy, Alpha, Secretary of the Convent of Mercy, Alpha, and a trustee of the said religious order in Jamaica, are defunct and have no incumbents or successors. And whereas it is expedient and desirable to change the offices listed in the said law in order to ensure the continuity of the corporation and to make certain consequential amendments, and whereas it is expedient and desirable for the corporation to be conferred with express powers to govern its management and administration, and whereas the corporation, acting in good faith and believing that the power to do so existed, in fact engaged in and carried out charitable and religious activities, contracts for goods and services, contracts of employment, and connected matters between the 12th day of April 1954 and up to the present time, and doubts have now arisen as to the validity of those actions by the corporation. And whereas it is expedient and desirable to remove all such doubts and to validate and indemnify all acts performed by the corporation in good faith outside of the scope of its powers during the period commencing on the 12th day of April 1954 and ending on the date of commencement of this act. Now therefore be it enacted by the Queen's Most Excellent Majesty, by and with the advice and consent of the Senate and the House of Representatives of Jamaica, and by the authority of the same as follows.
Can I just ask you, Mr. Curry, maybe it would be better if you just sort of summarize it for us as opposed to reading all the clauses? Yeah, so just so we have an idea of what the content, what the intent is behind each one. So clause 1
Okay,
will be the short title.
Right, so the short title is that the Act may be cited as the Sisters of Mercy of Jamaica, British West Indies, Validation, Indemnification, and Amendment Act 2021. So the intent here is to just encompass three of the main functions of the bill, which is firstly, it's an Amendment Act, but it is also to validate and indemnify acts that would have been carried out by the corporation during the period from its founding to present. Section 2 seeks to amend what I would call the primary section of the original Incorporation Act, and that is to replace the 5 posts that were named in that act as constituting the corporation. So as was discussed earlier, what we're seeking to do here is to appoint 2 designated positions, that is Area Administrator of the Sisters of Mercy of Jamaica, as well as the Secretary, as designated positions within the new corporation, but then also to have 3 members that are not tied to a specified position that are appointed by the Institute of the Sisters of Mercy of the Americas. But as was also discussed, the intention is for all 5 to be appointed by the president of that institute. And so this, as I said, I would describe it as the main section of the Amendment Act, in that this is the operative section that seeks to reconstitute the corporation. So this is really the most vital portion of the amendment bill. The reason for this, as was discussed, is that it's necessary to ensure the continuity and the very survival of the organization, because as of right now, none of its members or officers have the statutory ability to execute documents or carry out other acts on its behalf. So it's essential that the positions are changed as soon as possible. Now, Section 3 of the amendment bill is a necessary corollary of Section 2, in that it seeks to amend Section 3, subsection 4 of the Principal Act, which had stated that only 3 designated members of the corporation can use its common seal and execute documents on its behalf. What we're proposing here is that any 3 members, regardless of position, can execute documents and have possession of the seal of the corporation. But we also, in the first line here, where it says, unless its bylaws shall otherwise provide, give it the ability to amend this via bylaws in the event that the current circumstances of the corporation would require a more flexible arrangement, so that it wouldn't necessarily have to be 3 members, but they could designate it to a director or another officer within the corporation. And that is particularly important in light of the context that there's only 9 sisters left in the organization in Jamaica. And so it's necessary for some of the 5 appointed here to be overseas appointees. That is also relevant within the international context of the organization itself. So if we have 5 members, and if 3 are to be designated appointees to execute documents, we would want to avoid a situation where only 2 members are present here, and any document to be signed on behalf of the corporation would have to be sent elsewhere. So that is the intention behind allowing the bylaws to provide otherwise as it relates to the execution of documents. Section 4 of the amendment bill seeks to amend Section 5 of the Principal Act. Now, Section 5 of the Principal Act its intention was to set out certain powers that the corporation had the ability to carry out. While those powers were necessary, it's also necessary for it to have express powers as stated in the statute that governs it to carry out additional acts. Now, these are all listed here. So, starting with 4E, the corporation is currently registered as a charity under the Charities Act, and so this is merely to codify that power to enable it to have the statutory ability to carry out one or more charitable purposes pursuant to the Charities Act. So, even though it is recognized as a charitable organization, it's registered as a charity, but we do feel the need to codify its ability to carry out charitable purposes as defined under that act. Under 4F, the intent of this clause is for the corporation to be conferred with the power to make bylaws, policies, rules governing the management, constitution, control, and operation of the corporation. And this would include a power to create and appoint a board of directors and prescribe rules and regulations governing the functions of that board. So in a traditional charitable organization, as would be set up currently, maybe as a company limited by a guarantee, you would have the subscribers, and the persons who sit below the subscribers would be the board. Under this structure, we really only have members, and what we have found is that that's not conducive to efficient day-to-day management. So it's proposed that the corporation be conferred with not only the 5 new members, but also it would also have the ability to form a board of directors which would sit below those members and which would have the power to carry out more day-to-day management functions, or management functions which wouldn't have to be elevated to the level of the members in the same way that a traditional charitable organization would be run. Under 4G, this is a power that would normally be contained in the articles of a modern charitable organization. So this is merely to enable it to have the statutory power to erect, construct, lay down, and essentially to build any new buildings that it might deem necessary in furtherance of its objects. So while it may have done so over time, this is again just to give it the statutory power to codify its ability to do so. 4H speaks to raising funds, donations, funding, and gifts. That is again something that the corporation would have been carrying out since its foundation, and it does have the power, I think in the original act under 5C, Section 5C of the original act, to borrow and secure the payment of money, but that of course speaks to borrowing and obtaining financing at a commercial level. So this is 4H under the amendment bill, is to confer it with the power to raise subscriptions and funding as would be common within any charitable organization. 4I, this seeks to give it the power to operate bank accounts and to carry out certain ancillary functions that would accompany that, so to issue checks, promissory notes, and things that would be necessary for day-to-day business. 4J would give the corporation the power to invest monies and donations that it receives with a view to achieving a commercially positive rate of return, and is really intended as a means of preserving the value of its cash reserves. 4K, this is intended to give the corporation the power to employ persons, and that was something that was missing from the original act, and it would of course be necessary between all of the institutions that the corporation controls, including six schools at 26 South Camp Road and then 2 in Manchester. It's necessary to employ, I think it's in the hundreds of people to run those institutions. So we really would deem it necessary to have that statutory ability to employ persons. And 4L is intended as, it's essentially a catch-all provision. So whereas it must be interpreted in light of the powers before it, it is intended to give the corporation the flexibility to carry out any other acts that would be necessary in furtherance of its exercise of those powers. Section 5 is intended to repeal Section 6 of the Principal Act. Section 6 of the Principal Act reads, all of the provisions of this law shall apply to the dependencies. And so while this section wasn't necessarily prejudicial to the corporation, we just felt that in a post-independence context, the reference to dependencies would no longer be relevant. And so that was just intended as a means of cleaning up the act to remove that reference. Now, Section 6 deals with the validation and indemnity of the corporation and its officers. And the reason for this section is twofold. So the first has to do with the positions that were discussed earlier. So as I'd mentioned, the 5 positions in the original act no longer exist, and currently nobody holds those positions. But what has happened is over the years, the corporation still needs to operate, it still needs to enter into contracts, to employ people, and to carry out its functions generally. So these acts would have been carried out on behalf of the corporation by persons who do not have the express statutory ability to do so. So while those acts would have been necessary for the continuity of the corporation, the fact that they were not carried out by officers with the statutory ability to do so would bring into question the validity of those acts within the context of the statute. The second reason is on the basis of the powers that we just discussed. So there are only 4 express powers of the corporation as set out under Section 5 of the Incorporation Act. And as an example, there was no power to erect or construct new buildings, no express power to employ persons, and those were things that would have been carried out since the promulgation of the Incorporation Act to present. So again, because the corporation didn't have the express power to do so, the validity of those acts may be brought into question. And so the intention of this Section 6 is, notwithstanding the vacancies in those positions and the execution of documents by officers who would not be named in the statute, and notwithstanding the fact that there were not these express powers to employ persons or to enter into certain contracts or certain arrangements, to the extent that those acts were carried out in good faith and in accordance with the objects of the corporation, those acts would be validated, and the officers who would carry them out would be indemnified from liability for having carried out those acts in good faith. Section 7 deals with the vesting of property that was done pursuant to the Incorporation Act. So because the corporation is in essence being reconstituted by the appointment of 5 new persons and 5 new positions, the question may arise as to whether that reconstitution may affect the vesting of land in the corporation originally, which was based on the 5 original positions and persons. And so this section is simply intended to make it clear that all of the property that was vested in the corporation pursuant to the original Incorporation Act would continue to be so vested, notwithstanding that we're reconstituting the corporation based on these 5 new positions. So it doesn't grant any new rights or abilities. It's simply to clarify that the land remains vested in the corporation. Section 8 is, there's a similar concern there that the reconstitution of the corporation may affect the registration of the organization as a charity under the Charities Act. And so really this is simply intended to clarify that the reconstitution of the corporation or anything else in this act, it doesn't affect the continuity or the status of the corporation's registration under the Charities Act. Section 9, this is a saving clause which would indemnify the government, the Queen, and all others claiming through them from any liability that may arise pursuant to this Amendment Act. And that is a requirement, as I understand, of all amendment acts of this nature. So if there's any further questions, I'd be glad to assist.
Chairman, may I ask a question? If you go back to the amendment at section clause 2 of the bill, and it deals with the persons who are to constitute the organization, yes?
Right.
And the names of those persons then at A, B, and C are listed. And then it says, and their successors for the time being in the respective in the respective offices of area administrator, Sisters of Mercy of Jamaica, British West Indies, Secretary, Sisters of Mercy of Jamaica, British West Indies, and I stopped there. And it says 3 members of the Institute of Mercy of the Americas appointed by the President. So these positions, what happens if they don't exist? The first 3.
Well, I think it would be the first 2. Those are the...
Well, it says area administrator, secretary. Okay, yes, okay, first 2.
Right, so I think I'd explained earlier that even though the latter 3 members, it's specifically stated that they will be appointed by the Institute, by the President of the Institute, which is based in the United States. So, sorry, my apologies.
Could you repeat that? Just go a little slower for me. Even though what? Remember, I came a little late, so I missed some of your explanation. Yes.
Right, so what I was explaining is that, so just to break it down a bit, there is 5 members. 2 of them, as you've rightly pointed out, are tied to distinct positions. 3 of them are stated to be appointed by the President of the Institute.
Right.
Now, be that as it may, that the latter 3 are stated in the law to be appointed by the President. It is the intention, notwithstanding that 2 positions are named, for all 5 to be appointed by the President of the Institute. It's just that we wish to make it clear that the area administrator and the secretary must be among those positions, but all 5 are in reality appointed by the President of the Institute.
Okay. So those two offices, the office holders, will become members of the organization or whatever, leadership of the organization. And you're saying that if the positions don't exist anymore, what happens?
Well, it wouldn't be that the positions don't exist. What it is that the Act is silent as to the appointment of those 2 positions.
No, I'm looking at it as is, you know.
Mm-hmm. Okay.
I'm not going back to the past. I'm just looking at it as now. So therefore, for whatever reason, there's no more area administrator or secretary. I'm asking you, what is the fallback position if those 2 positions don't exist? And I'm asking you to tell me from the bill itself, does the bill provide for it, or is it a problem that we may face at some point? It does provide for it?
Senator Braham, I agree with you, through you, Madam Chair, because the bill having named the successors according to the title of the office, if that office either no longer exists, well, it would have to no longer exist, then we would be back here. We would be back here to appoint to those offices, because the President under this bill only has the power to appoint the 3 members.
So the answer could be is to put in a provision in there to make the President appoint in the absence of the position. The President simply appoints everybody. There is a slight off chance that the President may not exist. It sounds, yes, thank you. It sounds a bit far-fetched, but when you're dealing with bills, you know, you don't really want to come back here. Have you ever thought about what happens if the President doesn't exist? Or you want to just leave that and 30 years later somebody deals with that at that time? I'm not going to press that one. But certainly the one about the 2 offices, I am concerned about them.
Member Braham, my concern is actually, why are we establishing named individuals for the offices as well? That's a concern for me, because regardless of who the person is that sits in the position of area administrator or secretary, they could be appointed, and you didn't need to subject yourself to being cornered with a particular name for a sister as placed in the current amendments. So it allows you, whomever the individual is that occupies that position, they now take on the role and responsibilities.
But to answer your question, Madam Chair, I think the names, the rationale behind the names being included in the bill at this time is that you would have to name the 5 initial persons who hold those positions as of right now, just on a point of transparency, instead of just saying that there are these 5 positions and the president will appoint all of them and then there's no knowledge or transparency as to who they will be. So I think that's, I understand the concern, but I think that it was the rationale in naming the 5 individuals here. But as it relates to the positions, Marcy, and the relationship with the president, I'll just allow you to speak on that.
If I may. Before you go, members, it would definitely appear that this is an interim step. We are first doing the amendments and doing the indemnification and updating the bill to this phase. And from all we have seen, we will end up getting another bill that cleans up and makes possible a bill that will carry them fully into the future. So we would say, from going through the points here, that you would be back.
Right, that is correct. So the thinking is that this bill is to reconstitute the corporation with 5 new positions, but when we're back here on the next occasion, it would be to vest the property in a new company, a limited company, limited by guarantee, that would be independent of the legislature. And then that bill would essentially be to repeal the Incorporation Act, and so as to allow the Sisters of Mercy to operate independently. So that is the intention, yes.
Madam Chair, thank you so much. My name is Marcia Taicho, and I'm the Chief Executive Officer for the Sisters of Mercy. I just want to clarify the issue or the concern about the named offices. The area administrator of Jamaica and the secretary would be named in the new governance structure by the international leadership. As long as there's a Jamaican organization of Sisters of Mercy, there would be an area administrator, secretary. So it's a position that we felt would be named in the provision to recognize the fact that there'll be Sisters of Mercy in Jamaica organization. I don't know if that helps.
Thank you for your patience. So the committee is mindful of providing the necessary support to walk the bill through to its full acceptance. What we were discussing is why we hadn't structured it in such a way, since you're coming to Parliament anyways, where you would be able to get the approval to do what you needed to do going forward, to have structured your bill in the future in terms of where you wanted it to end up. That was a possibility for you with the support you would have had through the House of Parliament. However, we do understand in terms of time that you really need to be able to move and do some necessary work, particularly now. And as such, we would ask you to go back and structure in a way that gives you the best that you could have, but that we say, yes, go ahead with what you want now, and we would facilitate as fast as you're able to get back here with future amendments. We would be here to facilitate and pilot it through quickly as well. So in terms of time being of the essence, unless members had any other areas of concern, we would put our own committee report together while passing back to Parliament the approval of the amendments and the indemnification you're requesting here.
Thank you, Madam Chair. We're grateful for that.
Madam Chair, a quick clarification. I just want to make sure. Section 5A of the Principal Act in terms of the powers to deal with land is not being amended, correct? That
No,
will stand.
that will
Thank
stand.
you. Grateful. Madam Chair, if I might just add a few more comments, just for the record. Understanding that, of course, we will have to treat with this bill again. I do encourage the Sisters of Mercy to perhaps, in the second petition to Parliament, to look at perhaps asking us to not make you a body corporate, a statutory body corporate, which would give you a lot more room, I think, to do the charitable works, etc., that you're already engaged in. We had a tradition of doing this in a particular period of our legislative development. I think we have moved away from that now. And I see no reason why the acts of the Sisters of Mercy should necessarily be tied to the Parliament of Jamaica. I would be happy to see a bill seeking to repeal the act in the future.
I understand what you say, but there is real benefits in having a parliamentary bill as against something under the Companies Act. So I can imagine that why they might want to stay with Parliament, because, for example, they don't have to file any returns. So that may be an advantage.
And member, I will tell you, not only do you have the benefit of not having to file any returns, but I'll tell you, member Golding, I filed for my charity almost a year ago, and it has taken a long time, having been approved. Document is almost ready, and you're still waiting. And I've checked with other churches. What should be taking them 2 weeks is taking them in excess of 6 months. So once you are not given your certification from the friendly societies, your hands are tied and you can go no further, because you will not have a certificate to present. So you have to look at all the possibilities and see, weigh in the balance and see what works best for you.
Madam Chair, that is so true, but also as a body corporate, there are other acts that you will be held accountable and subject to as well. So yeah, you really do need to examine it and determine what is the least cumbersome way and most efficient way for you going forward. It's good to see you all.
Agreed.
So members, if it is okay with you, it would be wonderful for us to have this report tabled next week. That would be fine. So moved next Tuesday. I think that is December.
If I may, thank you, Madam Chair and committee, for hearing us at this point. Very grateful.
Thank you very much. So we will table the 7th of December, 2021 in Parliament. A report from this committee. If there are no further matters, may I ask that the meeting be called to adjournment?
So moved, Madam Chair.
So moved by Member Allen, so seconded by Member Braham. Thank you very much, members. Thank you very much.
Thank you. Thank you.
Yo, this is we're committed to reducing the impact of disasters occurring in Jamaica. We're ever ready.